Ms. Griggs, I sent a message to the clerk advising them of the agreement that we have in place. So we're just going to be waiting to be called.
Okay.
This technology has complicated the ability to have two attorneys come up here and whisper to me. We are back on the record in 213305 LT, Deborah Hensley versus Cynthia Cady. I have the appearances of everyone present. I had a brief conversation with the attorneys in my office. We are setting a trial date in this matter of September 21st, 2021 at 1 p.m. That will be back with me, and that will be by Zoom. All witnesses and documents that are to be considered should be present. There is an issue or a wrinkle that plaintiff is making efforts to sell this property. It is the understanding of the attorneys and myself that with 48 hours notice, the attorneys will work to facilitate making the property available for any buyer, inspector, contractor, etc., that the plaintiff has and needs to gain access to the property. When we return on the 21st, if plaintiff's attorney or plaintiff make representations to this court that either the defendant's attorney or the defendant have not cooperated in these efforts, it will be frowned upon by this court. Is that understood, Mr. Bogart?
It is, Your Honor. Thank you.
Is that understood, Mr. Robinson?
It is, Your Honor.
Any questions or any additional issues, Mr. Bogart?
None for me, Your Honor. Thank you.
Anything else, Mr. Robinson?
No, Your Honor.
We are all set in this matter. I will see you on the 21st. If there are documents that you want the court to consider, it will be extremely helpful if you would either mail copies to the court and one another or drop copies off or submit them electronically. It doesn't matter. I just like them beforehand. The share screen thing doesn't work for me in paper cases, okay?
Thank you, Judge.
Understood,
We're all
Judge.
set. Have a good day.
You too.
Thank you. You too.
Mr. Morton, please accept my apologies. I do not like making you wait. I know you have things to do. Ms. Griggs, same to you. My apologies for having the parties have to sit behind that.
No problem.
Understood, Your Honor.
Are you ready?
Yes, Your Honor.
Are you ready with Ms. Griggs? Okay, I just had to find it on my docket. 313414 LT. This is GI&I 9 Harbor Club versus Jada Griggs. I have noted your appearances for the record. Parties have had an opportunity to speak. How are we proceeding this morning?
Your Honor, the parties have agreed to enter into a conditional dismissal at this time. Rents retained are $6,007.02. Court costs of $167 for a total of $6,174.02. The payment date is September 21st, 2021. I advised Ms. Griggs that if the payment's not made on or before that date, then my client would have the ability to seek the case to be reinstated and then a judgment and writ to be entered. Further, I did advise for rights under MCR 4.201, including the fact that this would not be final for 3 business days. Additionally, went over the remaining portion of her rights. She did agree to those terms and did give me permission to be able to sign her name.
Is this Sarah payment or a direct payment from Ms. Griggs?
At this time, it's a direct payment from Ms. Griggs, Your Honor.
Ms. Griggs, did you hear what Mr. Morton just placed on the record?
Yes.
And ma'am, it's your understanding that there will be a conditional dismissal filed in this case that indicates that rent that's due as of today's date is $6,007.02. Court costs of $167 for a total of $6,174.02.
Yes.
And Mr. Morton further indicated to you or received your permission to sign your name to this conditional dismissal?
Yes.
And ma'am, you'll be able to pay this amount by on or before September 21st of this year?
Hopefully, yes.
And Mr. Morton also advised you that this order, once it's entered, will not be enforced until 3 regular court business days have passed?
Yes.
Okay. Anything else in this matter, Mr. Morton?
No, Your Honor.
Anything else, Ms. Griggs?
No.
Then Mr. Morton will prepare the document submitted to the court for entry. Once I receive it, I will sign it, and then the clerks will mail a copy to you, Ms. Griggs, okay?
Okay.
We are all set. Have a good day, ma'am.
Thank you.
Thank you. Shatoya Victor is this matter ready? 213350 LT Rawsonville Woods versus Shatoya Victor.
I'm here.
Ms. Victor, have you spoken to one of the attorneys from Rawsonville Woods?
I spoke with Danielle.
So the answer is yes. Okay. Is Danielle, Mr. Morton, are you able to do this, or do you need Ms. Paglia?
I would just say, Miss Victor, are you getting SEER assistance?
Yes, I
Okay.
provided her with the number, but I can give it to you as well if you need it.
Yeah, let's just move forward, Your Honor, then.
213350 LT Rawsonville Woods versus Victor. The parties' appearances have been noted. Miss Victor, your Sarah application number, please.
287666.
Miss Victor, you've been on this morning. You've heard the court say before that pursuant to Administrative Order 2020-17, this court is required to stay this matter in as much as you have filed an application for Sarah financial assistance. The court will mail out a notice of the stay to your attention. Please cooperate with whatever is requested for your Sarah application. If Sarah has not paid your landlord the amount that's due within the time allowed by the order, your landlord may submit a written request to this court to reopen the matter, okay?
Okay.
Anything else this morning in this matter, Mr. Morton?
No, Your Honor.
Anything else, Ms. Victor?
No, ma'am.
We are all set, ma'am. Have a wonderful day.
Thank you. You too.
Thank you. GNII 9 Harbor Club versus Richard Hatley. This is 213411 LT. Mr. Morton and Mr. Hatley, I note your appearances. Mr. Hatley, I'm going to ask you to turn your video on. Have the parties had an opportunity to speak this morning?
Mr. Hatley, did you speak to Attorney Danielle Paglia?
Yes, I did.
Are you in the process of seeking?
No.
SEER?
No. Mr. Hatley, I need you to put on at least a shirt, please.
Okay, yep.
Thank you. And then the only other thing I have, Mr. Morton, is Wilkerson.
Yeah. I believe, like I said, I know Ms. Polly was speaking to quite a few people as I was talking to
Okay.
one or two of the other tenants.
She's in with Miller, and then I'll start doing the defaults. I'll resume doing the defaults. Mr. Hatley, we're recording this and it's running live on YouTube. That's the only reason why I asked you to put on a shirt. This is the second hearing scheduled in this matter. You were both here at the original hearing back on August 25th. How are we proceeding this morning?
Mr. Hatley, just to confirm, do you have a SEER number?
Yes, I do.
Okay, then we're gonna, if you could please provide that SEER number for the court record, please.
It's going to be 296393.
Based on that, Your Honor, we'd ask that the SARE stay be put in place.
Thank you. Mr. Hatley, you've heard this court say a couple of times this morning that pursuant to Administrative Order 2020-17, inasmuch as you've made an application for Sarah financial assistance, a stay must be entered. The court will mail notice of the stay to your attention. I would encourage you to cooperate with any request for documents or information regarding your Sarah application. If your landlord does not receive the funding requested from the Sarah program within the time provided, they may submit a written request to this court to reopen the matter, lift the stay, and proceed with their complaint. Anything further in this matter, Mr. Morton?
No, Your Honor.
Anything further, Mr. Hatley?
No.
Sir, we're all set. Have a wonderful day. Thank you.
You too. Bye.
This is 313450 LT GI&I 9 Harbor Club versus Wilkerson. I have noted the parties' appearances for the record. Mr. Wilkerson, you've had an opportunity to speak to an attorney regarding your landlord-tenant matter this morning?
Yes, I was in the breakout room with a young lady earlier. I forgot what her name was. I apologize.
Okay. And Mr. Wilkerson, was there an application made for Sarah financial
Yes.
assistance?
Yes, I have
And
my.
you provided that number to Ms. Paglia?
Yes, I did.
Okay, and Ms. Paglia is nodding, confirming receipt of that number. Mr. Wilkerson, as I've indicated previously, inasmuch as you have confirmed or that your landlord has been able to confirm that you've made an application for Sarah financial assistance in this matter, the court pursuant to Administrative Order 2020-17 is required to enter a stay of this matter. Inasmuch as, notice of this stay will be mailed to your attention. As I've indicated previously, I would encourage you to submit all documentation and respond to all requests for information regarding your application. If for some reason your landlord does not receive payment of the rent in the time provided by the order, they may submit a written request to this court to lift the stay and resume the proceedings in this matter. Understood?
Yes.
Anything further, Mr. Morton?
No, Your Honor.
Anything further, Mr. Wilkerson?
How long is the actual stay? Because now that I'm done with garnishments, I have over half of what I owe like tonight when I get paid, and I get paid again like the next week. If I can pay, pretty much almost all of it off within the first 2 weeks of September. So I just want to know how long I have.
It's 45 days.
Okay. Oh, well, it'll be paid off before then. Okay. Thank you so much.
Have a good day, Mr. Wilkerson.
All right. You too.
Ms. Paglia, were you done with Ms. Miller?
Yes, I am done with Miss Miller.
Are you ready on that case?
Yes.
This is 213431 LT GI&I 9 Harbor Club property versus Julia Miller. Appearances, please.
Danielle Polly on behalf of the plaintiff.
Ms. Miller,
Yes, I'm here.
state your name for me, please.
Julia Miller.
Ms. Miller, this is the day and time set for the second hearing in this matter. First hearing was on August 25th, 2021. You failed to appear. The
Okay.
court's clerk mailed you a note. Nope, ma'am. The court's clerk mailed you a notice on August 26th directing you to appear here in person. You've had an opportunity to speak to an attorney from your representing your landlord this morning.
Yes.
Ms. Paglia, how are we proceeding?
At this time, we'd like to enter into a consent order for conditional dismissal. Where on or before September 13th, 2021, Ms. Miller shall either pay rents to retain of $2,978, court costs of $167, for a total of $3,145, which is due through the time period ending in September 30th, 2021. Or she shall vacate the premises and turn over possession of the rental premises to the plaintiff. And
Ms.
partial,
Miller, I'm sorry, go ahead.
partial payment by the defendant of the amount due would not prevent issuance of an order of eviction. Should a judgment enter, further, the action may proceed without further notice to the defendant or further process if the defendant fails to pay rent or vacate by September 13th, I apologize.
Ms. Miller, I cut you off before because I wanted to place the procedural history on the record. Was there something you wanted to say in this matter?
So yes, so I tried to join the Zoom meeting last August 25th, but I didn't know how to unmute myself. So I then led to failing to be there. I spoke to the court clerk and they told me that everything should be fine and just to join back today. But I do agree to leaving the premises within the 10 days.
Ms. Miller, have you sought financial assistance with this back rent?
I contacted them and it submitted to both Harbor Club and the Sierra, I believe, and I don't know if I didn't get approved or whatever the case may be, but I did submit an application and they never got back in touch with me.
Ma'am, put your
Yes.
viewfinder down so I can see your face, please. You did submit an application, or you're not sure if you submitted an application?
Yes, I submitted an application and it was notified to both Harbor Club and them, and I don't know if I didn't get approved or anything, but they did not get back in touch with me.
Ms. Paglia, do you have any information regarding a Sarah application in this matter?
When I spoke with Ms. Miller moments ago, she said she did not have a SIRA application or a SIRA application number. So this is the first time I've heard that she's completed a SIRA application.
Do you have any ability to check that information? Or Ms. Miller, do you have any email or documentation regarding your Sarah application?
No, it might have not been Sierra. I called one of the numbers off of the paper and it led to me going online and I completed the whole document and it said it was sent to both Harbor Club and I might not have been Sierra. I just know that I filled out a whole application and they told me they would get back in touch with me after I called them.
They told you over the phone? Did anybody
Yes.
send you? Did you receive it? Did you receive an email or a text message that says that you submitted an application for financial assistance?
Not that I believe. Let me check. Okay, so no, it wasn't Sierra. It was Good Nesting, I believe, and they said that they received it, and I'm not sure what happened. I'm not totally sure. I just gave up. I did contact Harbor Club after that, and they gave me, because I did contact them for another lease agreement, because they wouldn't even allow me to access my lease. So they had to send that via email.
Ms. Paglia,
Yes.
I guess that I'm a little concerned. Are you able to confirm with your client that I guess it sounds like Ms. Miller is trying to access resources, but hasn't quite been able to yet?
I don't have any information from them that they've received contact regarding any assistance or funding. I'm reaching out to them right now to see if they can confirm that information.
If you could, I'd appreciate it. Ms. Miller, don't leave. I'm going to do some other matters. But when Ms. Paglia lets me know she's ready, we'll come back on the record. There is still money available. And if you need that financial assistance, I'd rather us not push forward. Understood?
Yes.
Okay, thank you, ma'am. This is 213347 LT Rossville Woods versus Susan Thompson. Today was date and time for the second hearing in this matter. The defendant having failed to appear at the August 25th first hearing. There are no unidentified persons in this court's virtual waiting room. Ms. Thompson has failed to appear this morning, scheduled at 9 o'clock. It's now 10:34 by the court's clock. Mr. Morton, I note your appearance. How do you wish to proceed?
I'm sorry, Your Honor, I was sorting through everything to get back online with Rawsonville. Could you say the last name for me one more time?
Thompson, Susan Thompson.
Okay.
213347.
Okay, thank you, Your Honor. Your Honor, based on Ms. Thompson's failure to appear, we're asking a default judgment for possession only be entered. Rents retained are $1,046.35. Court costs of $164 for a total of $1,210.35. Again, this is a possession only action.
Thank you, sir. Again, this matter was scheduled at 9 o'clock. It's now 10:35 by the court's clock. Defendant has failed to appear. This is the second time she's failed to appear in this matter. Rent to retain of $1,046.35. Court cost of $164 for a total of $1,210.35. Plaintiff will submit the judgment to the court for entry. This is 213368 LT Trilogy Residences versus Jason Thomas. Today is the day, Mr. Morton, I note your appearance. Today is the day for the second hearing in this matter. First hearing was August 25th. Defendant failed to appear. There are no unidentified persons in the court's virtual waiting room. The matter was scheduled for 9 a.m. It's now 10:35 by the court's clock. The defendant has failed to appear again. Mr. Morton, how do you wish to proceed?
Your Honor, based on Mr. Thomas's failure to appear, we're asking a default judgment for possession only be entered. Rents retained are $3,524.84. Court costs of $164 for a total of $3,688.84. Again, this is a possession only action for non-payment of rent.
Thank you. Again, this matter was scheduled for second hearing at 9 o'clock. Defendant failed to appear as of 10:35 a.m. Rent to retain is $3,524.84. Court cost of $164 for a total of $3,688.84. Plaintiff will submit the judgment to the court electronically for entry. This is 213371 LT Trilogy Residences versus Raymore Davis. Mr. Morton, I note your appearance for the record. This matter was scheduled for second hearing this morning. At the August 25th hearing, all parties appeared, but neither Mr. Raymore Davis or second defendant Dave Netta Hayes have appeared this morning. And there are no unidentified persons in the court's virtual waiting room. Mr. Morton, how do you wish to proceed this morning?
Your Honor, at this time, based on Mr. Davis's and Ms. Hayes has failed to appear, we're asking a default judgment for possession to be entered. Rents retained are $2,623.43. Court costs of $186 for a total of $2,809.43. This is a possession only action for non-payment rent. I will advise the court that a CDC declaration was submitted, but as we've been advising parties when they've been contacting us recently, to informing them that the CDC declarations are no longer are no longer enforceable, but we've also been referring them to legal aid to be able to explain that to them if they inquire.
Thank you, Mr. Morton. Again, this matter was scheduled for 9 a.m. Neither defendant has appeared as of 10:37 a.m. Although Raymore Davis and Dave Netta Hayes were present at the August 25th hearing. Mr. Morton, the court does note the CDC declaration information contained in the verification form, but inasmuch as the defendants have failed to appear this morning, default judgment will enter with rent to retain of $2,623.43, court cost of $186 for a total of $2,809.43. If you submit that judgment to the court electronically, it will be forwarded to me for entry. This is 213374 LT Trilogy Residences versus Mariah Klingman and Micaiah Klingman. Mr. Morton, I note your appearance for the record. This is the day and time set for the second hearing in this matter. First hearing was on August 25th, 2021. Neither defendant appeared. There is no one in the court's virtual waiting room. There is no one by the name Mariah Klingman or Micaiah Klingman present. It is now 10:38 by the court's clock. Mr. Morton, how do you wish to proceed?
Your Honor, based on the Klingman's failure to appear, we're asking a default judgment for possession to be entered. Rents retained are $3,400 $11.22. Court costs of $186 for a total of $3,597.22. This is a possession-only action for non-payment of rent, in which we're asking a default judgment be entered.
Thank you, sir. Again, the matter was scheduled for 9 a.m. It is now 10:39 a.m. by the court's clock. Defendants having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $3,411.22. Court cost of $186 for a total of $3,597.22. Default will enter as to both defendants in this matter. This is 213379 LT. Today is the day and time set for the second hearing in this matter. At the first hearing on August 25th, 2021, all parties were present. Mr. Morton, the court notes your appearance for the record. The second hearing was scheduled at 9 a.m. today. It is now 10:39 a.m. by the court's clock. There are no unidentified persons in the court's virtual waiting room. There is no one by. This is the matter of Swan Creek versus Crystal Bartouche and Sean Bartouche. There is no one by that name in the court's virtual courtroom, no one in the court's waiting room. Mr. Morton, the court notes your appearance for the record and notes that the defendants have failed to appear as of 10:40 a.m. How do you wish to proceed, sir?
Your Honor, we were advised during this time period that this tenant has submitted the payment in full, so we would move to dismiss this matter without prejudice.
Based on the representations made by Mr. Morton this morning, this matter will be dismissed. I'm sure he will submit a dismissal electronically to the Civil Department for entry. This is 213382 LT. This is Billville Manor versus Christina Binkley. Today is the day and time set for the second hearing in this matter. The first hearing was on August 25th, where the defendant failed to appear. Court clerk sent notice to the defendant to appear this morning in person at this court. Hearing was scheduled for 9 a.m. It is now 10:41 a.m. by the court's clock. There is no one by the name of Christina Binkley in the court's main session. There are no unidentified persons in the court's virtual waiting room. Mr. Morton, the court notes your appearance for the record and that the defendant failed to appear as of 10:41 a.m. How do you wish to proceed?
Your Honor, based on Ms. Brent Binkley's failure to appear, we're asking a default judgment for possession to be entered. Rents retained are $3,218.18. Court cost of $166 for a total of $3,384.18. Again, it's the non-payment of rent for possession only default judgment we are requesting.
Thank you. Inasmuch as the defendant has failed to appear either at the court as directed on the notice or by Zoom, default judgment shall enter in favor of plaintiff and against defendant with rent to retain $3,218.18. Court costs of $166 for a total of $3,384.18. This is a recall of 213431, GI&I, and Miller. Ms. Paglia, were you able to make contact with your client regarding this matter?
I spoke with my client. They have not received anything from A Good Nesting or Sarah for Ms. Miller. However, I did speak with them and they were willing to give her until September 30th to get her affairs in order. So we would still like to move forward with a conditional dismissal, but they would be willing to give her the extended time to September 30th to either pay or vacate.
Ms. Miller?
Yes, Your Honor.
Were you able to hear the update from Ms. Paglia?
Yes, I was.
Okay. And ma'am, it's your understanding that there will be a conditional dismissal of this matter that indicates that $2,978 is due for rent. There's court costs of $167 for a total of $3,145, and that you will need to pay that amount on or before September 30th or be prepared to vacate.
Yes.
Okay.
And
Ms.
I just wanted to confirm I'd have Ms. Miller's permission to sign a conditional dismissal on her behalf.
Yes.
Okay, Ms. Miller, inasmuch as you're authorizing Ms. Paglia to sign on your behalf, she'll sign it, submit it to the court. Once it's entered, you'll get a copy. I would suggest to you that there are still financial resources available. If you need assistance, I would suggest that you again try to submit a SARA application through Wayne Metro or through the MISTA portal. When you receive service of the summons and complaint of this landlord tenant matter, it would have included phone numbers on how to reach out. You can apply online, okay? If you make that application, please notify your landlord. If there's someone else, if there's an agency who's able to pay this amount so that you may remain in your premises, I would just encourage you to do that, okay?
Yes.
Anything further, Ms. Paglia?
Nothing further, Your Honor.
Anything else, Ms. Miller?
No.
Okay, Ms. Miller, we're all set. Have a good day.
You too.
Thank you.
Thank you.
This is 213383LT Billville Manor versus Philip Powell. Today is the day and time set for the second hearing in this matter. The first hearing was August 25th, 2021. The defendant failed to appear. Court clerk would have sent notice to Mr. Powell that he needed to physically appear for today's hearing. He has neither appeared physically at the building nor in Zoom. There are no unidentified persons in the court's virtual waiting room. It appears that Mr. Powell has failed to appear. Ken, Mr. Morton, I have noted your appearance for the record. Mr. Powell has failed to appear as of 10:45 a.m. How do you wish to proceed in this matter?
Your Honor, based on Mr. Powell's failure to appear, we're asking a default judgment for possession only be entered. Rents retained are $1,996.90. Court costs of $166 for a total of $2,162.90. Again, this is a default judgment for possession only that we're requesting.
Thank you. Inasmuch as the defendant has failed to appear in this matter this morning, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $1,996.90. Court cost of $166 for a total of $2,162.90. Mr. Morton will submit that judgment to the court electronically for entry. This is 213388 LT GINI 9 Harbor Club versus Jonathan Austin. Today is the day and time set for the second hearing in this matter. First hearing was on August 25th, 2021, at which time the defendant failed to appear. Court clerk would have sent notice to Mr. Austin to appear at this court 15 minutes before the scheduled start time. Matter scheduled for 9 o'clock. It is now 10:46 a.m. by the court's clock. Defendant has failed to appear. There are no unidentified persons in the court's virtual waiting room. Mr. Morton, the court has noted your appearance this morning. How do you wish to proceed?
Your Honor, based on Mr. Austin's failure to appear, we're asking a default judgment for possession to be entered. Rents retained are $4,464.00. Court cost of $167 for a total of $4,631.00. Again, this is a default judgment for possession only. Thank you.
Inasmuch as defendant has failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $4,464. Court cost of $167 for a total of $4,631. Plaintiff's attorney will submit the judgment to the court for entry. This is 213395 LT GINI 9 Harbor Club versus Amber Davis. This is the day and time set for the second hearing in this matter. First hearing was on August 25th, at which time the defendant failed to appear. Court clerk would have sent notice to Ms. Amber Davis to appear in person at this court 15 minutes before the scheduled time. No one has presented to this court this morning in this matter. There are no unidentified persons in the court virtual waiting room. There is no one by the name of Amber Davis present in the court's main session. Mr. Morton, the court has noted your appearance for the record, along with Ms. Davis's failure to appear as of 10:48 a.m. How do you wish to proceed, sir?
Your Honor, at this time, we'd ask a default judgment for possession to be entered. Rents retained are $10,574.44. Court cost of $167 for a total of $10,741.44. This is a default judgment for possession only. I would only add that if it's on the record already, it looks like the tenant did previously submit a CDC declaration, and I'll refer back to my previous statements how that's no longer enforceable.
Thank you, sir. Again, this matter was scheduled for 9 a.m. It's now 10:48 a.m. by the court clock. Defendant having failed to appear, default judgment will enter in favor of the complainant Favor of complainant. Favor of plaintiff and against defendant with rent to retain of $10,574.44. There's court costs of $167 for a total of $10,741.44. Mr. Morton, you've made the statement on the record that there is a CDC declaration. The verification form that the court received on 7/29/2021 indicated that your client did not have such a declaration. I'll make that notation in the file, understanding what it means in this matter. Plaintiff's attorney will submit that judgment electronically to the court for entry. This is 213396 LT GINI 9 Harbor Club versus Ivana DeGraff and Reed. This matter was scheduled for the second hearing this morning. First hearing was on August 25th, 2021, at which time the defendant failed to appear. Court clerks would have sent Ms. DeGraff and Reed notice to physically appear at this courthouse this morning for the second hearing. No one has appeared in this matter. There are no unidentified persons in the court's virtual waiting room. There is no one by the name of Ivana DeGraff and Reed in the court's main session. Mr. Morton, the court has noted your appearance for the record, along with the fact that the defendant has failed to appear as of 10:50 a.m. How do you wish to proceed this morning, sir?
Your Honor, based on Ms. DeGraff and Reed's failure to appear, we're asking a default judgment for possession be entered. Rents retained are $4,505.65. Court costs of $167 for a total of $4,672.65. Default judgment for possession only, please.
Default judgment shall enter in favor of plaintiff and against defendant based on the defendant's failure to appear this morning. Rent to retain of $4,505.65. Court cost of $167 for a total of $4,672.65. Plaintiff's attorney will submit that judgment electronically to the court for entry. This is 213408 LT GINI 9 Harbor Club versus Mary Jones. Today is the day and time set for the second hearing in this matter. First hearing was August 25th, 2021, at which time the defendant failed to appear. Court clerks would have mailed Ms. Jones notice that she needed to appear 15 minutes before the 9 a.m. scheduled time for this matter. It is now 10:51 by this court's clock. There are no unidentified persons in the court's virtual waiting room. There's no one by the name of Mary Jones in the court's main session. Mr. Morton, the court will note your appearance for the record, along with the defendant's failure to appear as of 10:51 a.m. How do you wish to proceed in this matter, sir?
Your Honor, based on Ms. Jones' failure to appear, we're asking a default judgment for possession be entered. Rents retained are $5,263.64. Court cost of $167 for a total of $5,430.64. Again, we're asking a default judgment for possession only be entered.
Based on the defendant's failure to appear this morning, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $5,263.64. Court cost of $167 for a total of $5,430.64. Plaintiff's attorney will submit the judgment to the court electronically for entry. This is 313419 LT GINI 9 Harbor Club property versus Vincent Taylor. This matter was scheduled for a second hearing at 9 a.m. First hearing was on August 25th, 2021, at which time the defendant failed to appear. Court clerks would have mailed Mr. Taylor notice to appear at this courthouse 15 minutes before today's scheduled start time of 9 a.m. It is now 10:52 a.m. by the court's clock. This court has not received indication that anyone by the name of Vincent Taylor has presented in this matter this morning. There are no unidentified persons in the court's virtual waiting room. There's no one by the name of Vincent Taylor in the court's main session. Mr. Morton, the court has noted your appearance for the record, along with the defendant's failure to appear as of 10:52 a.m. How do you wish to proceed this morning, sir?
Your Honor, based on Mr. Taylor's failure to appear, we're asking a default judgment for possession be entered. Rents retained are $6,188.75. Court cost of $168 for a total of $6,356.75. Again, we're asking a default judgment for possession only be entered.
Thank you, sir. Inasmuch as the defendant has failed to appear as scheduled, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $6,188.75. There's court cost of $168 for a total of $6,356.75. Claims attorney will submit the judgment to the court electronically for entry. This is 213429 LT GINI 9 Harbor Club property versus Michael O'Connor. This matter was scheduled for second hearing this morning. First hearing was on August 25th, 2021, at which time Mr. O'Connor did appear. The court clerk would have sent notice for him to appear by Zoom this morning. Matter scheduled for 9 o'clock. It is now 10:53 a.m. by the court's clock. There are no unidentified persons in the court's virtual waiting room. No one by the name of Michael O'Connor in the court's main session. Mr. Morton, the court has noted your appearance for the record, along with the notation that the defendant has failed to appear as of 10:54 a.m. How do you wish to proceed in this matter?
Your Honor, at this time, we'd ask a default judgment for possession be entered. Rents retained are $3,580. Court costs of $167 for a total of $3,747.00. This is a possession-only action for non-payment of rent. We'd ask that a default judgment be entered. And just formally for the record, at the previous hearing, Mr. O'Connor advised that he does intend to, quote, vacate. However, my client has not received possession back.
Thank you, Mr. Morton. The court, based on the defendant's failure to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $3,580. Court cost of $167 for a total of $3,747. Plaintiff's attorney will submit the judgment electronically to the court for entry. This is 213441 LT GI&I Harbor Club property versus Michael Lewis and Charlene McCord. Today is the day and time set for the second hearing in this matter. The first hearing was on August the 25th, 2021, at which time neither Mr. Lewis nor Ms. McCord appeared. Court clerks would have sent notice to both of them indicating that the second hearing would be scheduled this morning at 9 a.m. and directing them to appear physically at the courthouse 15 minutes prior to the start time. It is now 10:55 a.m. by the court's clock. No one has presented to the court in person in this matter this morning. There are no unidentified persons in the court's virtual waiting room. No one by the name of Michael Lewis or Charlene McCord in the court's main session. Mr. Morton, the court has noted your appearance for the record, along with the defendant's failure to appear as of 10:55 a.m. How do you wish to proceed in this matter, sir?
Your Honor, based on Mr. Lewis's and Ms. McCord's failure to appear, we're asking a default judgment for possession be entered. Rents retained are $2,021.51. Court costs of $189 for a total of $2,210.51. Again, we're asking for a default judgment for possession only, Your Honor.
Based on the defendant's failure to appear for this second hearing, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $2,021.51. Court cost of $189 for a total of $2,210.51. Plaintiff's attorney will submit the judgment electronically to the court for entry. Last one I have, Mr. Morton, is 213451 LT. This is GI&I 9 Harbor Club property versus Terry Tubbs and Richard Tubbs. Today is the day and time set for the second hearing in this matter. First hearing was on August 25th, 2021, at which time neither defendant, Terry Tubbs nor Richard Tubbs, appeared. Court clerks would have sent notice to Tubbs and Tubbs to physically appear at this courthouse 15 minutes prior to the 9 a.m. start time. This court has not received indication that either Terry Tubbs or Richard Tubbs presented this morning. There are no unidentified persons in the court's virtual waiting room, and no one by the name of Tubbs in the court's main session. Mr. Morton, the court will note your appearance for the record, along with the defendant's failure to appear as of 10:57 a.m. How do you wish to proceed this morning, sir?
Your Honor, based on the Ms. Terry Tubbs and Mr. Richard Tubbs failed to appear, we're asking a default judgment for possession be entered. Rents retained are $1,915.95. Court cost of $189 for a total of $2,104.95. Again, this is a default judgment for possession only, Your Honor.
Thank you, Mr. Morton. And as much as the defendants have failed to appear as requested by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $1,915.95. Court cost of $189 for a total of $2,104.95. Plaintiff's attorney will submit that default judgment electronically to the court for entry. Mr. Morton, I have no files left. Please tell me you have no files left.
Yeah, I think I only have one or two, but I'm going to confirm. But I believe my co-counsel took care of those, so I think we're all set, Your Honor. And right before 11.
Thank you so very much. Have a good day, sir.
Thank you. You're same as well. You as well, Your Honor.
Thank you. Paige, I'm gonna bring the files down to you in just one second.